आप आज भी नहीं लाए, आप मास कॉपिंग वाले केसेस जजमेंट्स लेकर आए.
In this case also it has been stated.
That is the assistance which we receive. I am sorry. We have to lay down such a legal proposition. It has to be based on some factual, some precedential law or something which you can bring as judgments or something.
He will be debarred from not only in the examination in which he was found using unfair means, but in the next examination also. My lord, the admitted fact is that he was not given show cause before taking decision, my lord.
Yes.
My lord, on the last occasion I have placed before your lordship a judgment of 2016 of medical examination, interest examination, in which it was decided that in the case of mass copying, the rule of audio.
They had drawn a distinction between mass copying and
mass
individual
mass copying and the copying alleged using unfair single student or
individual case of unfair means.
Some students. Where large number of students found to be using unfair means or mass copying, then the examination itself will be cancelled. On the last one has been pleased.
The examination may be cancelled or whatever action.
Yes.
But principle of audio alter partem would not apply.
Would not apply. And this is the consistent decision of the Honorable Supreme Court right from 1970 till 2016. In that,
what kind of audio alter partem is required to be given? That is the question here.
Yes.
They say that since you had yourself admitted and before the concerned magistrate, and you have been already fined, you have been held guilty for the for having done cheating during examination. So for that purpose, now there is no purpose of giving you a show cause notice.
No, my lord, in this it was under compulsion because he was in custody. A student of young age.
This is not a consideration for the court.
No, my lord, I am saying
a
civil consequence is there. There's the criminal consequence, civil consequence, both are in a different yardstick altogether. Here I am going not only suffering the same examination, but the next examination. For the next examination also. Therefore, I am required to be given show cause.
All right.
The quantum of punishment, I can show.
Yes.
I can.
Yes, please address what are the judgments which you want to show.
No, my lord, the first judgment of 1970. Again, it was a case of mass copying. Therefore, the Honorable Supreme Court, that is of Bihar School Examination Board versus Subhash Chandra Sinha and others. It is 1970, 1 SCC 348, 648, 1 SCC. And the parallel, I am just having a web copy also, my lord.
Yes.
State of Punjab.
1970, Bihar School Examination Board versus Subhash Chandra. I am just placing the web copy, my lord.
Yes. Which para are you referring to?
My lord, I don't have that book, my lord, but I have
a net copy, no?
A web copy I have got.
The web copy of SCC?
It is downloaded from Kanun website, my lord.
All right. So which para? Please read that para. We will search it out.
It was also a case of mass copying. This is not a case of any particular individual who is being charged with adoption of unfair means, but of the conduct of all the examinees, or at least a vast majority of them, at a particular center.
I had asked you to go through earlier judgment on the last occasion. I remember clearly.
Yes, my lord.
And you have not yet brought it. It has been cited in this case.
It has been cited in this.
So you should have brought that judgment. There are three students.
That judgment is of
1962.
62.
Ghanshyam Das Gupta's case.
This is also cited here. In
But that was the case because there were three students there who were found cheating.
Yes,
how the process is required to be done, that what the Supreme Court has laid down.
Yes.
आप आज भी नहीं लाए, आप मास कॉपिंग वाले केसेस जजमेंट्स लेकर आए.
In this case also it has been
That
stated.
is the assistance which we receive, I am sorry. I adjourned the matter, I remember very clearly. On this point only.
I was under impression that your
On
lordship
the last
wanted
occasion also, you had shown only these mass copying cases.
mask.
Yeah, thereafter I requested you to please bring individual matters relating to individual cases. The Supreme Court distinguished Ghanshyam Das Gupta's case in this case.
Yes, my lord. Ghanshyam, that is 1962 supply 3 SCR 36, my lord. It can be seen.
Then there is another judgment which he has cited, 64, Ranchi University's case. All those judgments discuss how an individual copying case would be examined by the authorities. And of late also there are people.
In 90s,
आप लाए हो? आप ही नहीं लाए हो?
Lords, since I have no quarrel with the legal proposition, I was just trying to distinguish this case factually from the law laid down by the Honorable Supreme Court, as has fallen from a lordship, that the facts in the present are slightly different.
Show any law where what I have said is just a viewpoint.
Lords, I am just on the
It is not the law.
Lords, the petitioners are.
If we have to lay down such a legal proposition, it has to be based on some factual, some precedential law or something which you can bring as judgments or something.
Lords, I am on the exception.
Merely because a person has been convicted in a criminal case, can the principles of natural justice be avoided in your departmental proceedings? Like this is a departmental proceeding.
Lords, I was just going through certain judgments, my lords. I could
But
not.
going through, then please show those judgments to
I
us
could
also.
not find exactly, Lords, in which such kind of facts has been dealt by either this court or Honorable Supreme Court, where, Lords, the student has been.
All right, any judgments which you have brought,
Lords,
that is the assistance which is required. You don't.
then I will place, Lords, judgments in which, Lords, the Honorable.
पटना हाई कोर्ट से बहुत अच्छे जजमेंट जाते थे, हम लोग साइड वहाँ भी करते थे, पर लेकिन अभी तो आजकल आप लोग असिस्ट ही नहीं करते, तो करें क्या?
The Honorable Court has given certain
अभी
exceptions.
खुद ही निकालते रहे, खुद ही बनाए.
Then I will come with the exceptions, my lords. I will just rely on the exceptions which has been just drawn by the Honorable.
The concept of judge advocate is there in New York, in USA, not here. Where they have a concept of judge advocate.
my lord, to save time, Monday, my lord, I will be assisting.
As and when you want. It is now a leisurely litigation for you both, it appears.
Monday, yeah.
Monday we have old matters. We gave us Thursday only.
Item
Lord,
70.
this is a case of a student, therefore I
What can we do?
Monday, if your lordship, subject to your lordship.
Court is not going to be.
Because the next examination, special examination is going to be held in 2023. They are going to hold a special examination in this year also,
Yes.
apart from the annual examination. Therefore, if your lordships can.
Yes, we are keeping it next Thursday.